You go on the Art of Passing the Buck website, and it says victory over DOJ. Oh, sounds great. After a legal battle that lasted over a year, the Honorable Judge agreed that the content of these books does not violate tax laws and is protected by the First Amendment, therefore refused to ban these books. Okay, first of all, this is complete falsity. Alright, so here we got the original complaint from the IRS. Now, if you know how the structuring works, basically the IRS uses DOJ for their policing power, making a complaint against Gwen Wyckoff and Frank Ozak activities. We're talking about Mr. Ozak here. He had previously represented himself on business cards and in biographical descriptions posted to the internet as an attorney, although the California Bar Association does not list him as he admitted to practice in the state, nor does he appear to be admitted in any other state. Wyckoff acts as a trust administrator or protector for several of the abuse of trust described in more detail. Both defendants are heavily involved in the promotion, creation, and operation of the abuse of trust. As described in greater detail below, the defendant jointly advised individuals and business operators about the benefits of establishing abusive common law trusts, which they falsely claim will allow their customers to avoid the payment of federal income taxes. The trust they help create, and also in many cases directly assist in the management and operation of. Wyckoff and Ozak frequently act as paid trustees for the trust they urge and help their customers to create, and thus provide more than mere upfront assistance in the creation of trusts. Here's where it gets really weird. So through management of the taxpayers' assets and funds, the trusts purport to distribute their income to certain named beneficiary, to make it appear as if the trusts have no resulting tax liability. Such beneficiaries, however, prove to be illusory, offshore entities with falsified addresses that are merely intended to create the appearance of legality. Falsified addresses with offshore entities. I mean, that's as obvious as you can make. Ozak and Wyckoff represent two customers that the creation of such trusts allow individuals to legally avoid federal income taxation, because the trust, rather than the taxpayers, own and control the trust. The defendant's customers either do not file income tax returns or file returns that suggest they have little or no income. The trust tax returns similarly show distribution of almost all trust income to other entities and thereby claim no income. In fact, however, these trusts are simply the linchpin of an elaborate scheme to evade the payment of federal income taxes. In all instances, customers of the defendants who have created such trusts continue to exercise control over the trust. See, that's the problem there. So they pitch to their clients, well, you own enough control everything like this. Okay, but then they're having their customer still controlling the trust, the assets, and the property. They have created such trusts to continue to exercise control over the trust, assets, and property. Now again, this is fine if it's a irrevocable trust and they don't put it on the radar by funneling money through offshore entities, filing really weird returns. I mean, you're doing everything you can to raise red flags. In all instances, customers of the defendants who have created such trusts continue to exercise control over their trusts. And again, that's fine, it's irrevocable. But what these guys are set up always is irrevocable in these trusts. How can you own nothing, control everything, but then still control everything? Like these guys are doing. So it's just merely the legal fiction of the trust to create an illusion that they have no taxable incomes. So again, the whole point of using an irrevocable trust is, yes, you do want to have it so that it is not your asset anymore. You do want to have it so that it's lawsuit proof, but that doesn't mean that makes it tax proof. Now they're talking about how they used to get their customers. So they do so through personal appearances at meetings of like-minded individuals. Oh, okay. So like the guru seminars at a motel, right? Web-based publications and the sale of 2 printed volumes they helped write under an assumed name, right? So if you ever read that book, you might have thought that was one person writing it. Turns out it's 2 guys using pen names. Both volumes of which are replete with false statements about the taxability of trust and other income. They have gone so far as to take retaliatory action against employees of the IRS who are tasked with investigating the defendants and their schemes by filing frivolous administrative actions or lawsuits in order to deter investigations of their illegal conduct. Now, here's the really interesting part, and then specifically advise their customers not to cooperate in IRS investigations as well. Okay, in the light of the above, the United States seeks a permanent injunction prohibiting Wyckoff and Ozak from promoting the creation of these sham trusts. So yes, they are calling these types of trusts shams. I never made up that term. Promoting the creation of these sham trusts and making false statements about the taxability of the trusts. Okay, so then they list all of the penalties they're under. The defendants appear to have first latched onto the use of common law trusts as a means of tax evasion, after they personally created for themselves the Kensington Fund, an entity that itself was a common law trust and that they used for tax evasion, as well as an organization through which they initially promoted their ideas. So there we go. It turns out this private common law, private business trust isn't so private anymore when you have to deal with. These two entities were both vehicles through which James A. DeLulo was permanently enjoined from promoting tax avoidance schemes based upon fraudulent trusts, and is currently the subject of a bench warrant for his arrest for violating the terms of his injunction. Based on part of that determination, the IRS made a jeopardy assessment against the Kensington Fund of $56,734 as of April 30th, 2010. The Kensington Fund owes unpaid taxes, plus penalties and interest in the amount of $105,000. So, you think the $100,000 is bad? Well, just wait. It gets literally worse. In 2008, the defendants published and began to sell a 2-volume work entitled The Art of Passing the Buck, which contains numerous glaringly false statements about the Internal Revenue laws. So, look, I'm not saying, I'm a fan of the IRS with all this, but the second you start doing this stuff, you're inviting it. Anyways, as we can see here, Wyckoff and Ozak also spread patently false information about the IRS in books they promote. For example, they claim in The Art of Passing the Buck, the IRS is a foreign organization based in Puerto Rico and not part of the US government. Most problematic, the book falsely states the IRS has no authority to collect money and that federal agents have no jurisdiction over common law trusts. So here they are, having to deal with all this. I mean, imagine being the guru saying all this, and then you're literally dealing with what you said wasn't possible of common law trusts. The book falsely claims that the IRS cannot obtain records without a search warrant, when in fact, the IRS can lawfully request records through civil summonses that can be enforced by court order if necessary. The books further highlight several factors that the IRS considers in determining whether a trust is a sham, but ignore a fundamental requirement for a valid, irrevocable trust: the true relinquishing of control over the assets placed into the trust by the taxpayer. In this respect, the works utterly fail to mention a transfer to an irrevocable trust is invalid for tax purposes unless such control is relinquished, and instead advocates that customers merely take cosmetic steps to create the appearance of a relinquishing of control. Well, there we go. They didn't even follow what they said they would do. Own nothing, control everything. They don't even know what that means. So The Art of Passing the Buck also falsely claims that the instructions that the IRS provides taxpayers regarding the taxability of trusts is incorrect. It incorrectly states that distributions of trust income are deductible distributions of tax, to the point where little or no tax is due from the business trust. The books neglect to mention that distributions are only deductible if the trust documents require that all income be immediately distributed, or that distributions of trust income are taxable to the recipient. Now remember, on their website they were lying. They said that the judge said, well, this is protected by free speech. Well, in here, if you actually read the case, they say, rather, they constitute false, intentionally misleading, and or deceptive commercial speech that this court may regulate, if not ban, entirely. These statements all propose a commercial transaction, that taxpayers not merely set up common law trusts, but purchase at considerable cost The Art of Passing the Buck book, which used to be $400, by the way, and then directly engage Wyckoff once the trust has been created as described in greater detail below. There you go. Man, does that sound like a guru? They sell you the information that you need to even understand what the hell they're talking about. And then they upsell you on the, hey, well, now if you want the trust, I'll give you the trust. Now that you are taught the wrong way about trust. And by the way, later in this case, it was found by the judge that this was not protected free speech. What they were doing, they considered it commercial, transactional speech, which is not protected. Wyckoff and Ozak assist their customers in the creation of such trust, even though Ozak and Wyckoff's customers frequently continue to have control over the assets income. Once created, the defendants act as trustees for the trust and hold other supervisory or administrative roles. So this is where it gets pretty shockingly bad. So Wyckoff and Ozak falsely tell their customers that this arrangement is beneficial from a tax standpoint because individuals do not pay tax on income they receive that is paid directly to a trust. In actuality, individuals are responsible for income they earn. Wyckoff and Ozak also arranged through third parties, Mr. Dilulo most often, for the preparation of income tax returns for the trusts they helped create. Such tax returns claim the grantor's salary and other amounts as deductions. On their individual tax returns, the trust grantors routinely fail to claim the amounts they receive from their trust income. In turn, the trust returns report that the trust has distributed all of their income each year, negating any trust tax liability as well. However, when the IRS has investigated these distributions by attempting to trace the funds at issue, it has consistently discovered either that they did not in fact occur, that no money was in fact distributed, contrary to the claims in a trust's tax return, or that the distributions were made to other trust entities, upon examination, turned out to be sham entities. Alright, so now they're talking about another client of theirs. They convinced the client transferring all of his personal business activity to their trust, meaning that all business now is going to be conducted under a trust. Prior to the creation of the trust, Mr. Wilson reported that the income he derived from his business practices on Schedule C appended to his personal Form 1040 income tax return. Wyckoff and Ozak subsequently prepared the trust documents, created trust bank accounts, because remember, they act as trustees for these guys, and did other work to set up several trusts on behalf of Mr. Wilson. Wilson agreed that Ozak and Wyckoff would serve as trustees. One trust was to receive Mr. Wilson's business income, issue checks for his individual salary and for his business rent and expenses. The second trust was established for the purpose of owning all of Wilson's personal assets, a step which Wyckoff and Ozak said would insulate Mr. Wilson from creditors. And sure, irrevocable trusts do protect your assets from creditors. However, it doesn't all of a sudden flip your tax liabilities into non-existence. Wyckoff and Ozak informed Mr. Wilson that he would realize tax advantages from the creation of such a trust. Once the trust had been created, all income and expenses reported in connection with Mr. Wilson's business were reported on fiduciary income tax returns Forms 1041, filed by the Anna Corey Family Trust. Mr. Wilson was that trust general manager. So, see, there we go. The grantor was the trust general manager? I mean, make it make sense, people. Because they tried to make this into a business trust, they thought they could have, corporate-like roles that Mr. Wilson could fill in. So they're so sneaky. They're like, well, we won't make you trustee because that'd be, maybe the customers would catch on that we're setting up a sham trust. So we'll just make a position. We'll call it the manager, the general manager of the trust, which doesn't even make sense because the trustee is the fiduciary. You don't need a general manager in a trust. But I get it. They were trying to do the business trust scam. And he continued to operate his own business. After 2003, however, Mr. Wilson ceasing filing a personal Form 1040 income tax return and thus did not report his own salary income derived from his business activities. Okay, so see, now he's got all of his business going to the trust that he has control of. I mean, he would have literally been better off with just having his business stay in a limited liability company or something. Mr. Wilson submitted payments he received from his patients directly to the trust. Okay, so imagine doing business with the world. Okay, maybe you're a mechanic or a locksmith. I don't know. But you're having everyone write checks out to a trust. The trust thereupon paid Mr. Wilson a monthly salary. Oh, see, there we go. I mean, what the heck is going on? So, he's doing business under a trust, just looks weird. The trust thereupon paid Mr. Wilson a monthly salary. Again, that looks weird. As grantor. You literally are just showing that you created this trust all for your benefit. It wasn't intended for estate planning purposes, that's for sure. It wasn't intended for asset protection. It was intended for avoiding taxes and self-benefit. Ozak used money deposited with the trust to make at least 2 investments that they later informed Mr. Wilson had been so unsuccessful that the sum of the investments was completely lost. So there we go. Imagine having these 2 assholes as your trustee in your trust. And then they take on the role of the investment advisors. So now they just choose to throw your trust money into some investments that you don't know really too much about, which one of the other cases in this they mention. They tell their clients, it's better if you don't know where I'm investing this money. Then it gives you more innocence in any type of investigation. I wonder why they're planning for that, right? But even then, that didn't really do what they thought it would accomplish. So, sure, they tell their client all the money is gone, the investment went bad. Did they take the money out? Wyckoff and Ozak also informed Mr. Wilson that the trust could take deductions on their income tax returns that an individual cannot take on his personal tax returns. They informed him that they would arrange for the preparation of the trust tax returns. Hey, can trust have deductions? Sure. Just like a business can, right? Although a business has more deductions it can make than a trust. So, anyways, they're milking the trust write-offs, basically, taking it way too far. Even though these trusts were ostensibly created for Mr. Wilson's benefit, there we go, the defendant designed the trust to benefit them personally as well. The defendant's talking about these 2 brothers, Art of Passing the Buck authors. One of the trust documents states that Mr. Wilson was to be fined $100,000 for discussing trust information with others, a provision intended not only to benefit themselves, but designed specifically to keep Wilson quiet about the Anna Corey Family Trust. This is the trust they're setting up for him, were he to be contacted about the trust by the IRS. There we go. $100,000 fine, but don't worry, it protects you from the IRS. Okay. In addition, another document provides that if the trust were dissolved, Ozak and Wyckoff would get 51% of the assets or funds in the trust, rather than the customer, grantor, or beneficiary who were the source of the trust assets to begin with. I mean, look at these shysters. The IRS examined the tax returns for the Wilson Trust for the 2005 through 2007 tax years. In so doing it discovers that they all contained false deductions offsetting all of the reported trust income and reporting 0 overall tax liability. Mr. Wilson had never seen, nor had he signed, the tax returns Wyckoff and Ozak arranged to have prepared. So imagine being blind from all of this. You gotta feel bad for Mr. Wilson here. Indeed, he only had learned that the IRS had opened an audit to investigate the trust's tax liability when he personally received a summons. After an audit and examination of the Anna Corey Family Trust tax returns, however, the IRS determined that the trust should be disregarded for tax purposes. So there you go. They saw it was a sham trust, so therefore, they don't even see a trust. That's the problem with these sham trusts. So you can say all day, oh, the IRS has never called my trust a sham, but here we are, very similar Trust Guru Trust, and here we go. Like I said, the IRS will not even recognize it as a trust when they figure it out as a sham, because you're not using it for a trust purpose. You're using it for personal benefit. The whole point of a trust is for other people's benefit. Now, can you benefit out of a trust while you're alive? Sure, but not make it look like this, right? Both because the trusts were sham arrangements with no economic substance, but also because they were grantor trusts whose income was taxable to Mr. Wilson individually. Notice that they called it a grantor trust because the grantor still controlled it. being the trust manager. All right, and then the IRS, they calculated the tax liability. It was tons of money. As of April 30th, 2010, the total amount of tax deficiencies assessed in these 4 cases involving Wyckoff and Ozak's promotion of common law trust is $1.192 million. And then we get to the permanent injunction. As you can see, the defendants go along with this. They say, you know what, you do have jurisdiction over the IRS, so looks like they changed their minds. And then, yeah, they get their permanent injunction. They cannot work on anyone's trust ever again. They can't promote lies about taxes. And they can't operate their little Charles Arthur Enterprises Trust anymore. It is ordered, dated September 08, 2011. So there you go. I don't know how you could call that a win,